Good morning and welcome to the 2021 Balearic Yacht Show edition. My name is Miguel Ángel Serra. I'm partner of Lawyers Office Albors Galliano Portales and Tax and Legal Advisor of ANEN, the Spanish National Yachting Association. This year, the edition is a bit different than previous ones as we are joining forces with Palma International Boat Show to create a full experience online and off. This Tax and Legal conference will take around 45 minutes, and as this is an international show connecting the leading players in the yachting industry worldwide, we also wanted to have with us some of the best and well-known professionals in those areas, who will tell us about what's going on and what's new in their respective jurisdictions. To this purpose, we have today with us Freddy Desplanques, partner of Stream Law, who will talk about France. Hello, Freddy.
Hi, Miguel.
We have also with us Carla Bellieni, partner of Studio Piana Iluzzi Cheirolo Travatoni, Italy. Hi, Carla.
Hi, Miguel Ángel. Thanks for this opportunity.
Thanks to you. And we have also Irena Peric, manager of LeitnerLeitner Consulting based in Zagreb, Croatia, which is no doubt clearly an increasing market in the yachting industry. Hello, Irena.
Hello, Miguel. Greetings from Zagreb.
Thank you very much. Well, as time is very limited, we will center our attention in some of the most current issues which are being discussed in the Met. In particular, we will talk about the impact of Brexit in the yachting industry in the different jurisdictions. We will talk also about the COVID updates to know which is the situation in relation to eventual port, yacht, sailing, travel restrictions in each country. And finally, we will talk about the VAT updates in each country, which is always interesting as an evolving matter. Let's begin with the impact of Brexit. Freddy, which is the impact of Brexit on the yachting industry in the Med?
I think for the impact of the Brexit in the Med, I think we know all that with the end of the transitional period at the end of December, it will have an impact on the situation of yacht concerned by the Brexit. So we know that, first of all, we have to clarify how this Brexit has impacted the yachts concerned. So first of all, I think it is very important to know precisely the yachts concerned, because we have heard a lot about the impact of the Brexit without knowing exactly on which criteria we have to consider the impact of the Brexit. So I think we should distinguish, for example, the impact of the flag, because we can have UK flagged vessel operating in the Med or used in the Med, but I think it is not the main important thing in order to consider the impact of the Brexit. The most important thing to consider is the ownership, especially when the boat is owned by a UK entity. And this is the reason why it is really important to have this in mind when speaking about the Brexit. After considering the flag and the ownership, I think we know that the most important concern is to identify, the custom status and the tax status of your yacht. So especially at the end of this transitional period, we know that some of the managers or owners are speaking about their tax and custom status of their yacht without knowing exactly the meaning of this concept. The custom status means that we have to identify if the vessel is in free circulation or was in free circulation before the end of this transitional period. Because of course, if the vessel was in, the situation is not the same as for vessels that were out of the EU customs territory. Because the first impact of this Brexit is the fact that the UK is no longer part of the customs territory and the VAT territory for the VAT purposes. So if the vessel was in, the vessel is in free circulation, and you have to consider this free circulation status when operating or using the vessel, because we have yachts commercially operated and we have yachts privately used in the Med. The other point is about the tax status. So even if we have a link between the custom status and the tax status is based on the fact that you have evidence that you have paid VAT on your yacht. So it can be linked to various situations, such as the VAT payable on the acquisition or payable on the import. So you have to consider the taxable operation and the event that has occurred for the payment of this VAT. So it is clearly the situation we have in the Med, and the impact for the future is to keep evidence of the VAT payment so that, and the customs formalities that you have made before the end of this transitional period to be able to move freely inside the EU. So I think it is what we can say in terms of impact of the Brexit in the Med. And of course, the position of the French customs and tax authorities have been clarified regarding the situation of the vessel, especially when you want to use the returns good regime or the temporary admission regime for boats that are eligible for this kind of customs regime. So it is what we can say commonly and usually on the impact of the Brexit for the vessel used in the Med.
Okay, thank you very much, Freddy. Carla, is it the same situation in Italy in relation to Brexit, the VAT status, the status of union good, if the yacht was in the EU as of December 31st, 2020, when the transition period ended?
Yes, the general framework comes from the same rules coming from the European Customs Code, and even if in Italy we don't have official positions by the Customs Authority, we can take as good the rules covered by Freddy. In particular, we have to consider that for Italy, the situation may be special and have to be dealt with on a case-by-case basis, but with the same warnings and concerns raised by Freddy for France, considering that from a customs point of view, the Italian law had a rule linking the flag, European, Italian, or non-European, to the custom status of the yacht, but this rule ended for yachts in 2012. And this is something that must be considered in the analyzed of the single case, if there was a change in the flag before or after this date. Also, some concerns come from the special territory like the Channel Island or the Isle of Man. And we have to remember that the Channel Island were outside the European territory even before Brexit. So the situation described by Freddy has to be analyzed with reference to the difference in these territories. And the last point we could suggest to consider in the specific analysis of the yacht is the situation about the people on board and the difference in the limits of the customs territory after Brexit, giving the chance to have UK resident people on board of non-European yachts in Europe under temporary admission regime. As we know that the residence outside the European territory is among the relevant conditions.
Okay, thank you very much, Carla. Irena, do you share in Croatia what have been said about Brexit in France and Italy? Is there any particularity in relation to Croatia?
Well, in Croatia, we also share the view from Freddy and Carla. So UK is the third country. Maybe when entering a vessel or when you want to use a vessel in the Croatian sea, from a customs point of view, it should be first checked if temporary importation can be applied. If the vessel will be temporarily used in Croatia, then it can be avoided to pay customs duties and VAT in Croatia. However, if it will be permanently used in Croatia, then VAT and customs duties have to be paid in Croatia. That is maybe the first thing that should be checked. There are no specific rules for Croatia. Maybe only regarding Brexit, the Croatian tax authorities confirmed that UK companies which are VAT registered in Croatia do not have to appoint a fiscal representative in Croatia. So maybe that's important. So UK companies which are registered do not have to appoint a fiscal representative.
Okay, Carla, does in Italy, UK companies need to appoint fiscal residents? A fiscal representative, sorry?
Representative, yes, I do agree. This is something coming from official clarifications. So also in Italy, they don't need, even if in general for yachts, UK resident companies have also in the past appointed a tax representative because it was more efficient in terms of times to have the VAT number. But I can confirm that this is the same for Italy.
It is not compulsory, but maybe advisable from an efficiency point of view. Freddy?
Yes, it was already like this in the past, and I do suggest to use this kind of procedure.
Okay. Freddy, in France?
Yes, for France, it is the same. I think it is very easy to understand. It is the direct effect of the free trade and cooperation agreement. Just because in the agreement you have a specific tax protocol included explaining that for the companies based in the UK, you have a simplification regarding the VAT obligation, and this is the reason why the EU members are allowed to simplify the obligation in terms of appointing a tax representative for non-EU based company, which is the general principle. But for the UK companies, and it was officially recognized by the French tax authorities, because we have the list of the country for which there is no obligation to appoint a tax representative, and the UK has been included in the list. So officially, there is no need for the clients to appoint a tax representative. It is the legal background, of course, but we know that practically speaking, it can be good to have a tax representative to follow your operation, because if you have no representative in the country where the vessel is operated, because it is, of course, for the companies that want to operate commercially the boat in French waters, it means that you have to do all the VAT formalities, so VAT returns, VAT reclaims or refunds. So the main interest to have your VAT representative is to simplify the formalities, because the owning company is not directly involved in the formalities to be done. So if you want to do so in France, you have to be aware of the system and the formalities needed. So even if you have no obligation, it could be helpful for you to appoint a tax representative so that you can be helped for the formalities needed.
Okay, thank you very much. Well, I will summarize very briefly the Spanish position, which is basically the same commented by Freddy, Carla, and Irena before, which is a good thing to know, because not always the European criteria are being applied in the same way in all countries. So it's good news. And we could basically conclude that we should analyze the situation on a case-by-case basis, taking into account if the yacht was in the Union customs territory at the end of the transition period, if it was outside, if it was in the EU, if have ever been in the customs territory or have never been before. But I think that we can conclude in general that the main issue is the VAT status, the status of union good of the yacht, more than the flag, more than the ownership. Even it have to be checked again on a case-by-case basis. From a Spanish standpoint, I have only to say that something important is that based on internal regulations, UK flag yachts under 14 meters will not be allowed to charter anymore because this is reserved in the Spanish regulation to EU flags. So this is an important issue to bear in mind. Let's go then to the second issue we wanted to deal with, the COVID updates and its impact in each country. Could you tell us what is the current situation that COVID-19 is having in your countries, for instance, in respect to restrictions for yacht navigation, travel restrictions? Maybe we could begin with Irena, given that Croatia is the only country of those represented in this conference which is outside of the Schengen area. Irena?
Yes, that's right. Croatia is not in the Schengen area, but there are no special rules for sea borders generally in Croatia, so the same rules applies also for land borders, the same rule as for land borders. But the season is approaching. At 1st of June, the measures should be lowered. Now, currently, you have to have a negative COVID test in order to enter the Croatian border, but this should be changed as from 1st of June. So, last year, Croatia was also very liberal due to the generally it is possible to.
Irena, we are losing your sound a bit.
Yes, I'm sorry.
Okay, now.
Well, as I said, the Croatian sea border does not have specific regulation or rules regarding the entry due to COVID, so the general measures apply. In Croatia, from the 1st of June, the measures should be lowered, or there should be less restrictions when it comes to entering the border. The numbers in Croatia are really good right now, so a negative test will no longer be necessary to enter the border.
Any health declaration to be filed before arrival?
Yes.
Okay.
Yes, but it can be done online, and it's not.
It's not an issue.
It's not that. Yes, it's not an issue.
Okay. Carla, Italy?
For Italy, we have the need of COVID test, a negative COVID test. For some countries, you have to check because it is a changing situation. Also, a quarantine period is needed. Of course, not for European or Schengen area, but it is needed. And we have also a changing situation among the different regions in Italy. Now the movement between the different regions is allowed freely, and the time limit also for the fun activities in the evening is making wider the time of the lockdown and the limitations in the movement of people in the evening. This is quite important for talking about touristic and travel restrictions. The situation is changing. Our region, for example, will turn to white color, which means very low risk level in a few days, and the situation is increasing and becoming better every day. So we are expecting even better news in the next few days.
Okay, thank you, Carla. It seems that this better news is being already a trend, which is very good. Freddy, about France?
About France, I think the things are clear now. Even if we expect changes in the next weeks based on the circumstances and the context that you have probably heard. The current situation in France is very simple because we have a curfew, a national curfew in place. So at this date, it is the curfew starts at 9 p.m. And until 6 a.m. So of course, the movements of persons are limited during the curfew, except if you provide a mandatory certificate in order to justify your movement. So we have to consider this specific context. And from the 9th of June, the curfew will start at 11 p.m. So the timing of this curfew will be modified. From the 9th of June, we hope that the restaurant should be fully open. So I think it is very important for the activity in terms of tourism, because if you want to come into France, it is to benefit from all the activities that are possible. And normally we have the end of the curfew at the end of June. So on the 30th of June, normally it is the final date of the curfew. So we hope to have no curfew in place from the 1st of July. So it is the general context we have regarding the restrictions on the movement of people inside our territory. Regarding the movement of travelers, I think you have heard about the restrictions, or the current restrictions. Of course, we consider the impact of the current location of the travelers. So the situation is not the same for EU residents, residents in the Schengen area, and of course the people coming from outside the EU. So for the time being, we have the obligation for the arrivals from or within the European space of a PCR test, so a COVID test, and a sworn declaration. And we have a list of countries for which we have specification to respect. I think the most important thing to keep in mind now is the recent decision taken by the EU Commission in order to modify the rules for the EU citizens from the 1st of June. So normally, if you know, based on the sanitary pass, we should be able to travel freely for the EU citizens. So I think it is probably the first step of a real change regarding the movement of travelers. And of course, we could expect changes regarding the restrictions for the movements of persons coming from outside the EU. So I don't want to give details about the list of the countries, but of course the restrictions are not the same depending on the country for which you have a potential risk. So you can have quarantine. So of course these rules can evolve with the sanitary context and the information we will receive from these countries. So we should know that regarding the movement of travelers, the situation will be probably simplified for EU citizens and should be modified at the beginning of July for travelers coming from outside the EU. It is what we can say about the movement of person. The other aspects to consider regarding the effect of COVID-19 is the effect on the movements of yachts and vessels. So I think the situation was not very simple in France because probably you have heard that the navigation was restricted for non-EU flagged vessel, but in the Med, of course. But this decision was modified on the 12th of May. So this restriction was lifted so that the non-EU flagged vessel can now stop and anchor in the French territorial waters without any restrictions, except, of course, by considering the rules related to, to the areas where you are able to stay for anchor based on the protection of Posidonian areas. So because we have now in France new rules regarding the location of yachts depending on the length. So it is what we have noted recently, the fact that there is no restrictions for non-EU flags. And if you have, for example, to move from port to port, or if you want to move from the place where you you are birthed to go to the shipyard, you have to justify that you have a contract in place in order to specify the reason why you have to move the yachts from one place to another. So I think it is what we can say regarding the general rules on the restrictions of movements of both people and yachts. I would like to insist on other points that can have an impact on the activity for this summer season, especially because we receive questions related, for example, the obligation to be vaccinated for guests, clients, or for the crew. So it is not directly linked to the national measures in place related to the movements, but I think it is what we could expect from this sanitary crisis on the way of operating the boats for the future, especially if covered by charter agreements. Last year, if you remember, we have noted the owner's intention to add a clause regarding the impact of the COVID on the commercial operation, but we have noted questions related to the impact of vaccination for the crew. Is it mandatory or not? Or is it possible for the owner to require from the clients or guests to have the sanitary pass or the evidence of their vaccination before embarking? It is the type of question that we can have, and I think we have to consider this when reading or assessing the charter contract. It is what we can say for France. It is not typically a question limited to France, but I think it is the impact of the COVID on the charter activity.
Okay, perfect. Thank you. Thank you, Freddy. In Spain, the situation is also changing constantly, but we have to say that it's improving day by day. There is no longer yacht, port, or capacity restrictions being allowed. The number of passengers stated in the certificates of the yacht, plus the corresponding crew, logically. Our main worry is, as pointed out by Freddy, the current restrictions for non-essential trips from outside the Schengen area. And we indeed do not know what will happen on the 1st of June when the European Commission takes the decision. This will be obviously very relevant to analyze and to determine if the season will be a good or a better season, no doubt. We are not worried about the issue of PCR tests with 72 hours prior to arrival of the yacht to fulfill a health declaration, which must be fulfilled. But as commented by Irena, this is not an issue as of today because it is easy to obtain. I would ask you, Freddy, one specific question in relation to COVID, because with regard to the French commercial exemption in France, where the exemption of VAT on the hull is based on the number of trips in international waters along the previous year, could there be a tolerance or an accommodating regime in case of cancelled charters from previous year or from 2021 season?
The French tax authorities have explained their position at the end of last year on the doctrine. As you said, Miguel, we have in France a commercial exemption applicable on yachts, meeting some criteria. One of these criteria is to respect the 70% rules of navigation on IC. The problem was that the vessel were not operated last year in the normal conditions, and the French tax authorities have decided to consider last year as a blank year. So it means that if last year the yacht has respected the 70% rules, and if you are able to evidence that you have made the commercial trips to be eligible for the French commercial exemption, you can provide your statement and you can apply for this commercial exemption for this year. Okay, if the last year the vessel did not perform the conditions of 70% person of navigation on high seas because there was no commercial trip, because the vessel was not operated. This last year is regarded as a blank year, so you restart the clock this year. So you have the opportunity to provide a provisional statement to your suppliers when you want to benefit from this VAT exemption, but you know that you have to respect the criteria this year. It is mandatory in order to benefit from this commercial exemption. If you do not perform this year, potentially you will have to pay the VAT, unless the French tax authorities decide to consider this year as not a normal year and duplicate the same mechanism for this year. At this stage, they did not want to confirm this approach, because for them it is too soon to confirm that this year will be a blank year as well. I think they will consider the impact of the summer season. The point is that we know that when you want to operate commercially, the charter agreements are made in advance. So what we know from the current situation is that they will have an impact, because the way of signing the contract would be not the same for this year. The point is, it's really difficult to say if for yachts operated under the French commercial exemption, the impact will be so important as they cannot benefit from this French commercial exemption. I think the French tax authorities will consider the impact of this sanitary situation, but the only difference we have with what we have known last year is that we have no formal doctrine in place. So we have to wait for the end of this year to know if the same approach will be proposed for these years as well. So what I suggest, if you were eligible because you have respected, no problem at all. You maintain your status and you respect the 70% rules. If for any reason you did not respect the rules last year, you have to be sure that you will be able to do the commercial trip for all this season, so that you can avoid any risk regarding your tax status and the benefit from this VAT exemption.
Okay. Thank you, Freddy. I assume that this is under discussion with the French authorities and that we will know in the next weeks or in the 2/3 of the season, we will know something more about that.
We can hope, but you know, Miguel, that last year we have waited until the last days of the year. And so the final decision was made around the 25th of December. And so because of the pressure of the Yachting Association. So it's clear that the French tax authorities would like to know, have feedback from the season before deciding. So I'm pretty sure that we have to wait for the end of the year so that we can be able to have a clear feedback and the statistics regarding the commercial use of yachts in the French waters, based on the information received from the Yachting Association, and based on that we will be able to decide and to inform the French tax authorities.
Okay, perfect, Freddy, quite clear. Let's go moving to the final and ever-evolving topic of VAT. In France and Italy, VAT has been reformed too as a consequence of the infringement procedure raised by the European Commission. Is that correct, Freddy, Carla?
Yes, we agree. And from the same date, I believe at the end of the story, that means that for agreements closed before November 2020, the rule remains the same. That means that the reductions due to the navigation outside the European Union territory can be considered on the basis of presumptive flat rates stated for the past and deriving to the taxable base of 30% out of the full amount of the charter fee for yachts longer than 24 meters. I recall that for Italy, the part of the navigation established by the presumptive flat rates follows different percentages, varying depending on the length and the propulsion system of the yacht. For charters closed from 1st November 2020 on, the rule changed, and we have to consider the effective navigation outside the European Union. And this non-European navigation must be proved with adequate evidences. Among the means of proof, we have the AIS record of the navigation carried out by the yacht, which is the most important way. And we know that there are suppliers of service to give the report of the navigation actually performed in and outside the European territory. Then other proofs are the logbook, the documents about the charter, proofs of payment of the activities, the moorings, and everything the yacht has bought during the charter. The change will surely mean in general, we expect a higher amount of VAT for the same charter, the same tour, but also quite heavier administrative fulfillments, because the proof is not simply justifying the presence of the yacht outside Europe during the charter, but with a precise reference to the time spent by the yacht inside and outside the European Union. Okay. The owners we suggested to put in the charter agreements the condition about the proof, because the guests must be aware that the need of an effective and efficient AIS record is vital to have the tax benefit. So guests on board cannot ask to switch it off, for example, for any reason, and that all the documents proving the presence of the yacht become important. Okay. To avoid litigations with the guests, with the charter at the end of the charter, the rule put inside the agreement makes clear that the proofs are vital to grant the reduction for first to the guest, to the charter, which is the person who in practice will pay the difference in terms of tax burden. So okay. This is why we suggested to introduce this with careful attention, this rule in the agreements.
Okay, thank you, Carla. We are running out of time. Freddy, in a couple of minutes, the elimination of the lump sum reduction in France?
Yes, in a few words, I think it is the same approach as for Italy. So you know that in the past we had two options: the use of this 50% lump sum reduction. So the French tax authorities decided last year to inform officially the operators that it was the end of this lump sum reduction, just because it was not based on the real use of the vessel outside the EU territorial waters. So it is not any longer permitted to use it for the yachts commercially operated from France. As you know, it is applicable for short-term hiring services, so for our charter agreements. So it means that now, if you want to benefit from a VAT reduction, you have to evidence that the vessel was operated outside the EU territorial waters. So you have to evidence the time spent outside the EU territorial waters. So of course, we have the same approach as for Italy. We recommend firstly to have a specific clause in the contract to know exactly how to determine the time spent outside the EU territorial waters. So technical means are listed in the doctrine, so depending on the length of the yacht. So we know the how to determine this time spent outside the EU territorial waters. And of course, some professionals have already provided technical means to follow the vessel during the charter period in order to determine this part. I think it is very important to know that the owner is still responsible. Even if the vessel is operated by the charterer, if you want to apply this VAT reduction, you have to be able to keep all the evidence of this use outside the EU territorial waters. So I think it is what we can say in terms of impact of these new rules. I think that with the technical means available, it will be simple to follow the board and to determine this percentage. For the time being, we have no experience in terms of control from the tax authorities, so we will experience this new approach, and we will see in the future how this rule is applied and checked by the authorities. But it's certain that if you don't want to run any risk, you apply the full rate of VAT. And if you agree the principle of a VAT reduction, please keep all the evidence of this use outside the EU territorial waters. It is what we can say.
Okay, thank you very much, Freddy. Irena, any news from Croatia? You are the only country using the reduced rate applicable to accommodation services, which, if I'm not wrong, is 13% in Croatia. Is that correct?
Exactly. Yes, that is correct. We have this reduced VAT rate of 13% for accommodation services, which also applies for vessels, of course. So accommodation with breakfast, without breakfast, full or partial board, it's not important. This is now usual in Croatia. The standard VAT rate of 25% is applicable when we talk about the daily use, or a boat hire for one day, then the standard VAT rate has to be applied. The 13% only apply if we talk about accommodation services.
Okay, to be honest, I fully agree with the position of Croatia. It's not the position we have in Spain or even in France or in Italy, but I think it's the most suitable rate applicable to charter is the reduced rate from a qualitative standpoint. To be honest, I do not see the difference between chartering a yacht or being in a five-star hotel. So I think is a very good position. Talking about Spain, we have never had reductions on the taxable income, as you all know, based on sailing in international waters, as had France, or based on the length of the yacht, as the Italian system, or as it was Malta in the past. Anyway, I hope that now that the European Commission has spoken clearly, then Spain also adapts its VAT regulations for charters sailing in international waters. The only news we have from Spain that you probably have heard about is the charters departing from Melilla, one of the Spanish cities in the north of Africa. We have been working very hard with the port authorities of Melilla, with the Spanish tax authorities in Madrid, to reduce taxation on charter fees so that charters departing from Melilla will only be taxed at 0.5% of the charter fee, and not being applicable the use and enjoyment rule, which should mean to apply 21% VAT when the yacht enters the Spanish territory or the Balearic Islands. This is, I think, being very successful by now and could arouse the interest of many brokers, yacht owners, or management companies. Well, if I'm not wrong, I'm afraid we are out of time for now, and this brings us to the end of our conference. Once again, thank you to all the speakers. Freddy, Irena, Carla, thank you very much for your talks. Thank you to all the attendees, and I hope that it has been useful to all of you. If you would like to contact any of the speakers on the matters discussed in this conference today or to ask any other question, their contacts will be on the screen in just a minute. So thank you very much. Welcome to the boat show, to the Balearics Yacht Show, and enjoy the show. Goodbye. Thank you.
Bye-bye. Thank you.
Enjoy the show.
Bye.
Bye.
Bye-bye.